My name's Andrew Reid. I'm a social justice lawyer and Earth Justice, and I've been practicing for some 50 years. Um, it started out in doing movement work before I became a lawyer, and in the from the very beginning in the 1960s and 70s, I had an interest in opposing the oppression of peoples of any kind. I was active initially. I was active in the prison movement, and then prison justice movement. Also active in the civil rights movement in the 60s, and then became involved through that. And I grew up in Oklahoma, and there were a lot of Native people there. Became involved working with Native people, the first people of the United States. And that's some 50 years ago, and now I'm still working for Native peoples. I initially started doing essentially civil rights work with Native people, where there's a set of laws called federal Indian law that the United States has uh, adopted to govern their relationship between the United States as a colonial power and Native people. And most lawyers that practice law do not understand the colonial context of federal Indian laws. They represent Native peoples and Native nations. They don't do it in a colonial context. They live within a colonial box. And even scholars that write the books that are used to teach and train Native people, Native lawyers, which we call Indian lawyers, or they do not put it in a colonial box. They put it in a colonial box. They don't put it in a within a uh, international context. About 10, 15 years ago, I began to realize that it was a dead end, that federal Indian law is basically meant to assimilate all about everything that's involved in federal Indian law is the slow forced assimilation of Native people, as determination of their sovereign status, of their status as independent First Nations that pre-existed the arrival of the nations up here, and began to understand and realize that there's a hidden agenda, there's a hidden story here, and a hidden argument that had to be developed. And was invited to write an article for the journal on my perspective based on my experience and my research. I also teach. I've been teaching for over 10 years at a law school in Denver, Colorado. I teach the Indigenous people's rights and international law course. I also teach the environmental justice and ethics course, Earth jurisprudence, and there's a lot of overlap between Earth jurisprudence and Native worldviews. Native people are basically viewed as by the colonial powers as natural resources, not viewed as people. And they're viewed as natural resources to dominate. And the colonial rule, the colonial laws, institutions, colonial institutions, one of which is federal Indian law, uh, have been created to dominate the first people so that they can take the resource, mostly natural, but even human resources. But I was invited to write an article, and there hasn't been. So what I wanted to do was to expose the what's dispose the context to show what's between the lines of this centuries old relationship between colonial powers, and that it's become so ingrained that we no longer talk about it as being a colonial relationship. And of course, the colonial ruler, the dominant of power, they're not interested in having that brought out. They do not want to be exposed as colonial powers, because colonialism under the current international law has been condemned. It's a violation of the right of self determination, a right of fundamental rights of freedom and liberty and so forth. And they're settled. It's settled international law that colonialism violates most of the human rights of peoples and has been condemned, roundly condemned. And that over the past 300 or 400 years, these laws have been used to forcibly assimilate them. Forced assimilation is genocide. And therefore, the institutionalization and the slow destruction of first world peoples, of fourth world peoples, of first peoples and fourth world peoples, that is genocide. And it's a slow genocide that is a creeping and an unending oppression of indigenous people, ultimately leading to their forced assimilation structure. That is something I term as slow genocide. And there needs to be a recognition of that, and it needs to be defined and acknowledged under the global condemnation of genocide, under the Convention on Genocide. Most states also, the United States has federal laws against genocide. So there are federal laws that condemn what it itself is, and it's a failure to recognize that. One of the ways under international law, when you have an outlier, a nation, in this case, it's not a nation, it's a state, a political entity that refuses to abide by the law against human rights violations and laws against genocide and colonialism, they refuse to abide by that. You have to expose them, call them to task. We call that under international law, we call that shaming. So one of the purposes of this article is to expose what is going on about all around us quietly and covertly, and that's a slow genocide.